All right, everybody, we're gonna just begin our third session of the day. And so we'll jump right into things. And so it's a privilege to have Heather Connors here. Heather is the Executive Director of the Center for Guardianship Excellence, where she strives to ensure that those in need of guardianship have guardians trained to support their values, goals, and preferences. In her prior role as the Director of Research for Guardian Community Trust, she designed and launched the Guardianship Academy, which provided training on issues surrounding guardianship. It was that work that provided the foundation and inspiration for the Center for Guardianship Excellence and the work she's doing today. In addition to her work, she serves on the boards of multiple organizations, including the Center for Guardianship Certification, the National Guardianship Association, where she was the president last year in 2023, and the Central Massachusetts Agency on Aging. She's a member of the Massachusetts Guardianship Policy Institute and serves on the advisory committee for public guardian services. Heather is a nationally certified guardian. She earned her doctorate of philosophy in gerontology's policy studies from the University of Massachusetts, Boston, where she completed a dissertation titled Autonomy versus Protection, a comparison of physicians, elders, law attorneys, and protective service care managers. It's with great privilege today that we have Heather, and so let's give her a loud but quiet virtual welcome.
Hi, everybody. Thank you for having me today. As many of you may be aware, there is now a Bill of Rights for people with guardians, and I am really excited to bring that to life for you today. You may have heard of it, but have you known how to use it? And that's really the key question for us as guardians, is how do we use the tools that we have been given? So today I hope to introduce you, if you haven't been introduced to the Bill of Rights, and give you some ideas for how you might use it in your practice. As Luke mentioned, I am Heather Connors. I'm the Executive Director of the Center for Guardianship Excellence. And we are an organization focused on protecting the rights of adults with and without guardians. At our heart, we're a research organization. I'm a researcher by training, and my focus has always been on trying to understand the needs of people who aren't able to make decisions for themselves, and trying to figure out what it is that we can do to support those people. So our organization provides training on ethical guardianship. We offer our training at no charge, and we look at opportunities to train people on how to be guardians, how to find alternatives to guardianship, and what can be done to support people when they're in the guardianship itself. So we do encourage you to come to our website, come to our events. We have lots of support and training for guardians that hopefully you will find helpful. So I know I can't see you, but I bet if I asked you who of you have heard of the Bill of Rights, which was introduced in 2022, I bet not too many of you would say, oh yes, I use this on a regular basis, because it is something that's a little bit hidden. So let me just tell you a little bit about how it came about, and then we'll go into the tool itself. So the Bill of Rights came out of the 2021 National Guardianship Summit, which was held at Syracuse University Law School. The summit occurs about every 10 years or so, and it brings together guardians, scholars, people with disabilities, people who have had guardians, and other people who are engaged in guardianship work. And the goal of it is to make recommendations for the next decade of work. The first recommendation that came out of the 2021 summit was to convene a task force to develop a Bill of Rights for people with guardians. The task force included guardians and people working in the aging and disability sectors, as well as people affected by guardianship and people who may at some point become in need of a guardian. So what we did was we looked at a range of tools and existing documents that included bills of rights that existed in some states. We also looked at laws and local practices. We looked at articles, all in order to develop this new document. The document was approved by the National Guardianship Network and is now available for courts and guardians and organizations to use. The decision was made that it wasn't just one formal document, but that it could really be tailored to the needs of each organization. So what's really exciting about it is it can be made for really formal purposes like lawmaking, but it can also be kind of made a little bit more simple so that we can present it to people that we have as guardianship clients. I will point you to the QR code that's on the screen right now. If you follow that QR code, it'll come to the Center for Guardianship Excellence's website. And that is our version of the Bill of Rights. We made it a little bit simpler so that it's something that can be shared with people with guardians. The Bill of Rights document has 5 parts that are listed here on your screen. Access to justice rights, core human rights, decision-making rights, the guardian's authority, and restrictions. We'll look at each part and talk about how these information is being used by guardians and in relation to conversations you might have with families or other stakeholders that are involved in the person's life. And as I mentioned, you can use that QR code if you're interested in trying to see the Bill of Rights while we speak. So you may be asking yourself, what is the point of this? Why do I need something like this? And my argument is that it's going to help create a better outcome for people with guardians. And I will just mention the language that I use. I don't say under guardianship when I remember. I generally don't say a person under guardianship. I tend to say a person with a guardian, and I just think that's a more person-centered way of using the language. So when I'm talking about this, I'm looking at what can be done for a better outcome for the person, as well as for the guardian themselves too. So let's talk about what better outcomes might look like in the world of guardianship. First, successful guardians are going to try to create trust with the client, with their family members, caregivers, and other people. The Bill of Rights is being used to conduct these kind of conversations to address the fear and mistrust that might create a faster path towards a bond. Secondly, advocating for client rights and needs is part of your job. The Bill of Rights shares a lot of details about the client's rights. It supports demands for the clients in writing whenever we might need to have that tool in hand. Thirdly, people who want to debate a guardian's role or authority respond well to having that documentation. So sharing copies of the Bill of Rights is a helpful tool so that you can get control of situations and resolve conflicts about who has the authority to make certain decisions. And we'll talk about sometimes being in a situation with a family member or a facility or something like that, and having a conversation about whose decision really it is, and whether and kind of whose voice gets to win in the conversation. The Bill of Rights will help you kind of stand up for yourself and stand up for the client in that situation. Finally, guardians are using the Bill of Rights to discuss boundaries and set boundaries that save time and reduce challenges. So we're going to look at the 5 sections of the Bill of Rights, and I'll share some ways to use them. Then you can decide how and when you might use the Bill of Rights with one of your clients. One way that guardians are using the Bill of Rights is to draw out any concerns or fears or mistrust that the client might have at the beginning of the situation. If you've been in trainings that I've done at the center, you've heard of one of my very favorite clients ever, and she would say to me, Heather, I always heard that guardians were hostile. And I love the way that she said hostile. But she would say, I always heard that guardians were hostile. And when I work with you, I don't feel like you are. And that always kind of stuck with me. It's sort of like a badge of honor that I keep, that I was like, I was not a hostile guardian. Because there are a lot of feelings about guardianship. And you certainly know that what's been in the news about guardianship in recent years has not helped the situation. So there's a lot of fear and mistrust about what a guardian does and what a guardian can and might do, whether a guardian is going to try to take over the situation. And so being able to talk to the person about the way you do guardianship is very important. And saying something like, I have this document that talks about your rights. Is this something you'd like to talk about? that can be a powerful way to open the conversation to see if they're interested in hearing more about it. So let's jump right into the first section of the Bill of Rights, which is access to justice rights. There are 8 points in the access to justice section. And just kind of from the beginning, and this is something that you know from your guardianship orders that you receive from the court, that the guardian is only given rights specific to the appointment. So you as the client retain the rights that are not given to the guardian. In numbers 2 and 3, we learn what was supposed to happen when the guardianship first started. So you have the right to hire a lawyer and who advocates for the outcome you want, and you have the right to be present and participate in court hearings. 4 and 5 talk about the action the adults can take if they're dissatisfied with you. And this is something that is an important component of guardianship, is letting the person know that they do have the right to contest the guardianship if they don't agree with it. If they don't agree with you as the guardian, or if they don't agree with the guardianship itself, they get to go, they have the right to be heard and let the court know about the situation. Number 6 talks about the assessments that can be done, that focus on the individual's capacity rather than incapacity, and the possibility that the assessment can lead to ending the guardianship. And I think the capacity versus incapacity part is important. When we lead with a strengths-based approach, we're much more likely to find that the person can do more than when we assume that the person is not able to. For those of you who have seen the little ad that's going around on TikTok about the woman with Down syndrome who is talking about what she can do, and when you say that she can't have a margarita, if she orders a margarita at the bar and you give her juice instead because you've made an assumption about what she can do, well, then you're limiting her opportunities. When she wants to move out and you say, no, you have to stay at home and I'm going to tuck you into bed at night, well, you're limiting her opportunities. If you're not teaching her things in school, you're limiting her opportunities. And that's a real weakness-based approach to looking at things. And it's something that we've had in the history of guardianship. You know, we've used language like incapacitated person and ward to say that this person does not have capacity, they lack something. Instead, the Bill of Rights is encouraging us to look at what the person can do and look for their strengths. Number 7 and 8 talk about the right to have complex legal ideas explained in a way that the person can understand. And that's really important to be able to make sure that the person is able to understand the situation that's going on. Many of us can't read legalese. I mean, it takes an advanced degree to really understand the law. So to be able to have this broken down into something that is understandable is very important. What I argue is that a lot of this information may be brand new to some of your clients. They may not realize, and I think back to Britney Spears, and I feel like I never expected to talk about Britney Spears as much as I have in the last couple of years. But one thing that really strikes me is her saying that she didn't know she had the right to contest the fact that her father was guardian. She didn't want her father to be guardian, and she did, but she didn't know she had a right to contest. So I think here is important to recognize that people do have these access to justice rights that may not have been made aware of from the beginning. So when you have these kind of conversations, you might be letting people know that you are different from people they've come across in the past. Maybe they haven't had their rights kind of supported in the past, and you're letting the person know that you are going to be sort of a different guardian. You're going to be one that is supportive of the person. And that can make for a really good start to the relationship. So somebody's having trouble with feedback. Is that on my side?
I'm not having that issue, and I think Sometimes it's just a specific Wi-Fi or technology issue.
Sounds good. Thank you. So what I'm saying is this can be a really good way to start off a guardianship and really get things going on the right foot, is to let people know that you are going to be taking their rights seriously and supporting their rights in all sorts of legal matters. And like I was saying, this conversation is going to promote trust. What if you were to share this infographic or even just this portion of it with a new person who seemed fearful or resentful? They were angry that you were the guardian. They were angry that they have a guardian. They feel as though they don't need a guardian. Well, that's a good conversation to have with somebody. I understand you feel as though you don't need a guardian. Let's talk about that, and let's talk about what your options are. So what do you think this would do for your relationship? If you said something like this, does anything jump out at you? Is there anything we should explore more in detail? Is there something we should be working on for you? Can you picture yourself saying this to a client and seeing kind of how this starts your relationship? Pop it into the chat if you could see yourself doing this and what you might start with. Good. So Lynn is saying that accommodations might be identified. So if there are accommodations needed in order for the person to be seen and heard by the court, you might be able to identify those from the beginning. Perhaps for some older guardianship cases, it would be good to share. So somebody who has been with a guardian for some period of time may need to know this information. What would you want to do differently if you didn't have a guardian? Is really great language that Melissa brings up. I like that this is a way to guide what could be an awkward conversation and build rapport. Excellent. Excellent. I love that. So I think all of this is the point of making this really concrete, is to help you use this tool and make sure that you're able to make conversations with people. Oh, I like this. It's a way to change the narrative for someone who had a previous guardian that they didn't vibe with. So this is a good way to say, let's change this up, and how can we lead with you at the center? What are your goals for the next year? That's great. We're going to be talking about goals in a couple minutes too. Excellent, thank you. Let's talk about, okay, so Dan is asking how this applies to a person who's mentally unstable who does not want a guardian. So the person who doesn't want a guardian, when we say mentally unstable, I'm assuming the person has maybe mental illness or is in really kind of a bad state at this moment. This could be an opportunity to talk about that a guardianship is not permanent. You know, even though we may have language called permanent versus temporary guardians. A guardianship can always be reviewed and should always be reviewed. And so to bring this person, help them get the treatment that they need at this moment, and let them know that you're planning on reviewing this on a regular basis to see whether the guardianship remains appropriate, I think could be very important. I like Connie's answer, asking them to help ask what they might need to exercise their rights with another support that they have in place. So there might be other places that the rights are not being supported, and what can you do in those places? And I like the idea here that you're making this conversational. You're trying to help the person understand where you're coming from, rather than you coming in and saying, you know, I'm in charge, this is what I'm doing. So I'm looking here still at the chat. A difficult situation is a person with dementia that's not aware of the condition, is not accepting of it. Absolutely. And there are other places here through the Bill of Rights that we could talk about other ways to find rights that you can support more easily, because that's really hard when somebody doesn't understand their condition, certainly. So let's talk about some core human rights. I think at the core of this is the right to be treated with dignity and respect. This can be kind of a challenging thing for some people. Some people are kind of literal and say, what does it mean to be treated with dignity and respect? But I think we all have an idea of how we want to be treated. And I think having the conversation with the person is going to be important here. What is important to you? My son was in an argument with a friend, and somebody said, "What is wrong with you?" And he was so incredibly offended. He was so offended. And I didn't know that that language was so upsetting to him. He's 10 years old. He's still a kid. But the idea that something was wrong with him was just a shot in the heart. It was really upsetting to him. So to find out from the person, what does it mean to be respected? Is there language that is really off limits for you? What does it mean to be treated with dignity? And how might that dignity change? So sometimes dignity is something that can be challenging for family member guardians, for somebody who may no longer have the same ideas about what dignified is that they might have had in earlier life. So maybe the way they dress. Maybe it can be hard for a family guardian or a family member to see somebody dressing more in a casual way in sweatpants and kind of a sweatshirt or something like that, a t-shirt, when they used to dress up more formally earlier in life. And recognizing that their right to be comfortable may be different than their desire to be looked at in a specific way. So you might start with, we've worked together on some things. How is that working for you? I've been your guardian now for 3 months. Is there anything that I'm doing that you would like me to do differently? Is there something I can work on? Asking, is there somebody who's taken advantage of you, for number 10? Anybody who's denied you services that you wanted, is there anything that you want me to be looking into? Is there something that I can investigate for you? Number 11 might be something like, as time goes by, what do you want to stay in control of? And I think to the person who has dementia, who may not understand that their situation, saying, I want to help you remain as independent and in control as possible can be very empowering. So being able to have that conversation with somebody is going to be good. Letting the person know that you will not be reading their email. You're not going to be opening their door without knocking. You're going to respect their privacy. I missed religion. Certainly, are there cultural practices that I should know about? Are there rituals that I should know about? Number 15, I'm happy to discuss anything you want to share. Or you told me about so and so. And we made some changes to allow you to do such and such. Is that still working? So really trying to tailor this. This is going to be person-centered. Tailor this to the person. And finally, the right to a competent guardian. I've worked hard to be a competent guardian for you. Is there anything you want me to talk about that could be improved? Going through what you accomplished with the person can be helpful in helping the person understand your work. So you may have been working with this person for 6 months, and you know that you have gotten a lot done. You have helped the person get housing. You have helped the person get onto benefits in order to get food and subsidized housing. You've done all of these things, but the person is saying, you know what? I'm still in the situation that I don't want to be in. I still have a guardian. What's going on? For you to talk about what you've done and then what you would like to do in the next 3, 6, 9 months could be really helpful, that you could get some ideas about what the person wants. Again, like I said, this is about being person-centered. So would it build trust and confidence for you with you if you ask the person to choose one of these rights to really focus on? So in the next 6 months, which is the most important one for me to be focusing on? And that can be a good opener for the person who is not really happy about this guardianship, but you have to get them on your side. Your thoughts on this? The third part of the Bill of Rights talks about the decision-making process. So we know that even though guardians are named as decision makers, we're expected to include our clients in the decision making as much as they want to be involved or are able to be involved. These principles are documented now so that our clients are able to see them, read them, have copies of them, whatever it might be. So number 17 talks about the right to participate in all decisions. 18 talks about the right to receive needed medical services. 19 and 20 talk about property decisions and the right to have a capable guardian managing them prudently. And then finally, 21 talks about that you can't share information with family members or other people unless the client gives you permission. So I'm going to ask you, what situations might be relieved or resolved when clients or family members understand what their role is in the decision-making process? How do you think this could be helpful to you? The reason family is mentioned, so sometimes the guardian has a situation where the family is kind of at odds with what the client wants. So how can this set boundaries? Before the appointment, I meet with the client and discuss what they do not lose after guardianship. I love that. I think that's great. Jason said trust. Excellent. The setting of goals is my most effective tool for making a bond. I think that's really great. You're really laying out with the person what it is that they can expect of you, what you can expect of them, and what end goals you're looking for. I think that's great. I'm going to give you an example of where the decision-making tool or the rights part of this tool was helpful for me. We have a client who has dementia, and her family, the client is Black, the guardian care manager and many of the staff at the agency is white, are white. And the client's family wants to move her to another place with more Black people. And so we had a big conversation about this and thought that this would be a really good idea and give her some more peers and more maybe cultural competence and whatnot. And when we spoke to the client about it, she said, no, I'm really happy where I am. I know the staff, I know my roommate, I'm happy with my roommate. I don't want to move. And so we explained that to the client's family. And they said, you don't understand. You're coming from a different culture than we are. You don't understand where she's coming from. And she's incompetent. She has a guardian. She can't make these decisions. So we really had to have a big conversation first as a team before we presented it back to the family, but then back to the family of talking about what our expectations are of the guardianship. We understand from our mission is that we listen to our clients and we make the decisions that they want to make. And we know that she's comfortable. She tells us that she really is happy. She's participating in lots of events and activities. She's has a good relationship with her roommate. She has a good relationship with the staff. The staff know her well. They're very responsive to us. There are a lot of reasons why she's in a good place. And so being able to say, there's this Bill of Rights, and the Bill of Rights says that she has the right to fully participate in decisions, especially about her care and where she lives. And that is the reason that we're going to listen to her on this decision. And we were able to kind of back that up in our documentation to let it remind us that this is the reason that we made this decision. So Rebecca's saying when we use a tool like this, they understand the rules and what lane you are in and how you are there to help their wishes be heard and considered. I love that. That's great. All right. So having a conversation about decisions you participated in, proof that I've properly managed, I tell no one your private information. All of these are conversations you can have with a person. So kind of like some of the comments before about having a check-in with a person, I think a check-in with the Bill of Rights is very useful. You can sit down and say, let's look back at the last year. Let's review your legal rights and see what I've been doing to support you and what we need to do next. So this is going to help you develop a care plan of sorts, but it's also going to help you bond with the client, we hope. So we think this is going to be a helpful tool for you there. The fourth part of the Bill of Rights explains the guardian's authority. It's a perfect balance to the decision-making rights section because it clarifies what the guardian can be authorized to do by the court, but only with due process. It can be helpful for clients and their families to know which of these 8 assignments you've been given. Rather than read this list to a client, you might want to explain in real-world situations what you've already faced together or are facing now. So you might say, the court has given me this authority, but my intention is to such and such. I've been authorized by the court to apply for your benefits. I'm allowed to place your money in an account that will be used for your needs and no one else's. Your cancer treatment decisions have been assigned to me. Here's how I intend to include you in the decisions. I follow a code of professional standards and I use my court-appointed authority to X. Again, this is right about the time that we're going to be wanting to meet with the family to have a conversation. Other interested parties, maybe the facility wants you to do something that you're not comfortable with or that you don't think is right. These are the protections in place for Joe and the court-assigned responsibilities that I am obligated to fulfill. Now you can see why Joe's wishes need to be my priority. So with my client whose family wanted her to move, we had to say, you can understand after reading this document, this is what best practice says that I, as the guardian, should be doing. I should be considering her wishes, and her wishes are not to move. We had this conversation over and over with this family. This family wanted to take her on a sort of international vacation. And we said, all right, well, if this is what she wants, and we said, do you want to go on vacation? And we were a little bit hesitant about the whole thing because she's in a nursing facility and she has oxygen. And there was a whole lot of reasons why we weren't thrilled about this, but we wanted to talk to her. And when we talked to her, she said, no, I don't want to go anywhere. I'm happy. What don't you understand? I'm happy here. So again, having to return to the family and say, these are her wishes. This is what she tells us. As it turns out, this did help us bond with the family. That's not our goal. Our goal is to bond with the client, but it really did help us bond with the family to let them understand that we do come from a professional code of conduct. We're not willy-nilly making decisions. We're not saying we get to rule, we get to make all the decisions, none of that. We do have a method to our decision making, and this is what it is, and that was helpful for us. All right. Next, I want to talk about the restrictions section. Clients should know, and I'm just looking at the chat. It often comes up with post directives, family client wants versus the client wants versus the facility wants. Definitely, absolutely. Yes, having to kind of sometimes fight with a facility about, I know in Massachusetts, we have a lot of facilities that really want you to sign them, we call it a MOLST, as soon as the person is moving into the facility. They want that on record and they want to have it in hand. And being able to say that just because she's an 85-year-old person doesn't mean she has to be a DNR. She may have very different needs and wishes and wants and values. And so being able to kind of stand up for that client's wishes is very important there. So talking about restrictions, clients should know and understand if any of these restrictions apply to them. Family and the client both need to know that these are not your choices. So going back, these are not willy-nilly, just I'm making stuff up, I'm throwing spaghetti at a wall. That is not helpful. We want to let them know that the court has made these decisions, but that just like with everything else, nothing is permanent. There is the opportunity to have this revisited by the court. And every state has different ways of getting back in front of the court. But making sure that the court the person knows that this isn't forever. If you want to change them, then we go back to the access to justice rights at the very beginning. Make sure you get access to an attorney. Make sure we get you heard by the court again. So again, the court's decided you may or you may not. Letting people know that if something made sense at the beginning of the guardianship, it may no longer make sense now. And I think about the person in the very first question I think we had, that was about a person who was mentally unstable. And you think about a person who may not have been on meds for a mental illness, or may not have been getting the proper nutrition and hydration that they needed, or had some sort of medical condition going on that resulted in delirium, or whatever it might have been, so that those restrictions were pretty significant at the beginning of the guardianship. Very often the guardian is going to be able to help the person get some of those situations under control, whether by consenting to meds or consenting to medical care, making sure the person is able to get whatever medical needs they need met, in order to kind of peel back that guardianship. So maybe something that was very restrictive at the beginning can be less restrictive, or even terminated in total. Yes, and so as Elizabeth is saying, I think it's helpful to let our clients and notice parties, family members know that as guardians, we're monitoring the condition of the individual. If their condition improves, we will advocate to have their rights restored. And I think that's so powerful. Again, you know, I don't remember, and I apologize for not looking this up ahead of time. In Washington, do you call it a permanent guardianship, or is it just a temporary and then another guardianship? Do you use the term permanent? Just throw a yes or a no in the chat for me. Most are permanent. Okay. So there are states that are moving away from the word permanent, just to say, yes, it's not temporary, but we can always go back to court. And that is something that is a very helpful thing for people to know. So knowing that, thank you, Jason, that's helpful. Emergency guardianship can be as short as 5 days. That's fantastic. Letting providers and caregivers and other people know about the Bill of Rights is also a very helpful thing, because it's going to kind of put some parameters on the way you do your job. It's going to let people know what they can expect of you and how you are. And basically, going back to my friend from the beginning, know that you're not hostile. You're not a hostile guardian. That you are the kind of guardian that takes seriously the rights of the person you're working with. And making sure that these rights are well understood by everybody. You're not hiding this. You want everybody to know the rights that this person maintains, so that they can call you on it and say, you know what? I don't know if she was really involved in that decision. Are you sure you had a conversation with her? Because that's not what she told me. You know, maybe it's embarrassing to get called, but this is the best thing for the person, is that somebody recognized, oops, I made a mistake and I need to go back. So I think that's a really, really powerful thing, to share this Bill of Rights with all involved, whether it be people at the nursing facility or the care facility, or family members, or the person's attorney, or whomever is involved in the case, as well as the client themselves. Okay, so full as opposed to permanent. That's great. Thank you. And document those conversations. Definitely document it all. If wherever you can, you want to document. But I think the Bill of Rights is a useful tool whenever I can, in my documentation, say National Guardianship Association standard number 13 says XYZ. I feel like I'm being supported, that something is supporting my decision. That again, Heather didn't just decide this because she was in a bad mood this day. Heather made this decision based on best practices in the field. And again, this is another tool to do that. So you'll be able to say, I had this conversation per the Bill of Rights in order to make sure that the person really understood their rights. So I encourage you to think about how you can use this. Would you print it off and bring it to a client at your first meeting? Would you just have a conversation? Certainly not all of your clients are going to be able to read or even read English. So being able to let the person know as much as possible about what their rights are, reading them, talking about them in clips. You don't really probably want to talk about all 21 rights in one sitting, but talking about the ones that seem to be most pertinent could be very, very helpful. Can we order the Bill of Rights from the NGA? Is that the question, Mindy? So the Bill of Rights is on the NGA's website, yes. So you don't need to pay for it. It's available free on the website. It's also available on the center's website from the QR code that I gave you there too. Okay. I'm just trying to, I have 2 more minutes, so I just want to make sure I get all of this in, and then I'm going to follow back onto the chat. So like I said, the Bill of Rights is designed to be printed, shared, discussed. You can download it at the center's website. You can also download it off the NGA's website. There are plenty of places to get it, but you can use the QR code here on the screen if you're looking for it. I think it's useful to have it as an available website, as an available resource for those really hard conversations. And I think the one that you started with, the person who has experienced mental illness and is in sort of a deteriorated state, who's really angry about the fact that they have a guardian, that they don't understand why it's going on, or the person with early dementia who doesn't really understand that they need a guardian. Being able to say, I understand this, and we will work on trying to get the guardianship reversed. But in the meantime, these are the rights that I'm going to support you in, and what is most important to you, I think could be very helpful for people. That helps it helps your client know that you're protecting them or trying to fight for their rights. And it also makes sure that other people understand that the person's rights are your top priority. They shouldn't be ignored. So my last slide is just going to let you know what you can see at the Center for Guardianship Excellence. If you are looking for free CEUs for CGC, we offer CGC CEUs, that's a lot of letters, for free for all of our live events. Our recorded events are $35 per credit, but it's a great way to get a lot of your CEUs if you're a certified guardian. So I encourage you to come to our website for online opportunities, for webinars, for support groups. We have a support group where guardians can talk to each other and get ideas from each other. So I encourage you to check it out. And so now I have 15 minutes left for questions. I'm just checking the chat to see if there's anything that I missed that I needed to respond to. But otherwise, please go ahead and pop things into the question and answer or the chat, and we can talk about any questions you have. Okay, so Leah is saying that this would be helpful for people in memory care or with memory challenges, so that they have something tangible, something to hand out. I think whenever you can have a leave behind, and that's I think something that we try to do at the center quite a bit, is create virtual job aids that you can print off and hand out to somebody. What does it mean to have a guardian? What does it mean to be a guardian? All of these things can be very helpful, and I think that it's useful to just reinforce the things that you're saying. Oh, I love that Elizabeth is planning to make it part of the business's policies and procedures. That's awesome. That's exciting. That's what it's meant for. That's great. And Elizabeth Stone has already used the Bill of Rights. Awesome. Are there any other questions? I know people have been chatting throughout the presentation, so maybe we covered any of the questions that people had. Is there anybody who has a situation in which you think the Bill of Rights would really apply well? Is there, you can even unmute, are people able to unmute, Luke?
They're not, but if they raise their hand, I can unmute them.
Okay. If somebody has a situation that you think the Bill of Rights could apply to, we could talk that through. Is anybody wanted to talk about that? Oh, okay. Rebecca has a question about maintaining safety risks with rights. I can't post a PDF in this session, but if you go to if you follow the link in the notes, I think my notes are being handed out to participants. All of that is available.
Yep. So in the auditorium where you click the join link and where you'll leave feedback for Heather in a little bit, there's another link right next to it that is access to all of her notes, and you can get it from there.
Excellent, thank you. Melissa, I know you have a question, or Rebecca, I guess, has a question about how you weigh safety risks with maintaining rights. Do you want to follow that up? All right, well, Rebecca tries to figure out how to do that. I'm going to talk to Chick here, who is saying, I have a client who flags down cars, gets into strangers' cars and goes away. It worries me because she's cognitively impaired. She has the right to associate with whomever. What can I do? So in some states, you actually have to get authority from the court to restrict whether a person associates with somebody. But I think there's a difference between, I think there's a safety issue there, that she's putting herself at risk. I think you would have to have some sort of a behavior plan in place to help her understand whether risks are worth the risk, whether the harm is worth the risk. So being able to kind of understand, find out if she understands what she's getting herself into, and what could happen to her if she gets taken away, and what could happen if she goes into a stranger's car might be important there. So Tamara is saying, I have a client that is very educated and feels that she should be making the decisions. However, we've tried and it was very detrimental. So I've given her a list of her rights so she can dig in on the ones that she feels strongly about. That's great. And Wendy is saying, for, I think, Chick's question, behavior plan, and then petition the court about how your client is putting herself at risk. I think that's important. Kevin has a hand up.
Okay, Kevin, you can unmute and talk. Sounds like you're muted, Kevin.
There's some really great conversation going on in the chat about people with real risk in really risky situations, and keeping them safe, and trying to create behavior plans, and maybe looking into the service providers to find whether there's a more safe housing or placement that the person could be in. Valerie is saying advocating for a neuropsych eval. Seeing ways to limit the court, not restrict, limit within the court, to limit for her safety. That's great. These are all really great ideas. Kevin, I don't know if you're able to talk. I think in some of these situations, that's when I would, like other people have mentioned, go to court and ask for guidance on how to proceed, see what the court suggests doing. So she's So can I talk to about the rights as it pertains to a client who becomes pregnant? Can you tell me a little bit more? Maybe Laura can unmute, Luke? Laura Schmidt?
Sure. You just needs to raise your hand and I
Oh,
can.
okay.
All right, you're unmuted, Laura. If you just have to unmute yourself. There you go.
Can you hear me?
Yes.
Yes, I was thinking that responding to her news that an attorney on her behalf, as she may consider adoption. And what does that mean in regards to the limitations that are on her now? The only thing that we have is guardian of the person, and she maintains her right to socialize as she chooses. And so when we took her on, our goal was to see how she could be removed from the guardian over time as she demonstrated her ability to participate in community and provide for her well-being. And of course, 2 days after we were appointed, she eloped into the community to act on her well-being. And so I still am putting out these ways that she needs to demonstrate, because I think that her acting out stems from many things being, family dynamics and some things that happen. But I just want to protect her rights, even though she's, chosen to, she says at this point, keep the child, and perhaps either keep the child or give it up for adoption. So I just want to make sure I'm protecting her and her rights in this manner.
Yeah. No, again, I think this also would have to go back to court because you don't have any authority as the guardian over the child. That would be outside of your jurisdiction. Unless Washington is very different from Massachusetts, but I wouldn't expect so. So I would think that you would have to get guidance from the court on how to proceed. Certainly not. Yeah, I think that Child Protective Services would probably have to become involved to make decisions about how the child is managed. But that's a very tricky one when you're in a situation that you're trying to protect the person's rights to have relationships and be in sexual relationships, and yet the person, but certainly many people who don't have guardians get pregnant unexpectedly, and have to make decisions. So I think at that point there needs to be a team decision about what happens next. I'm reading in the chat, the guardianship doesn't apply to the child, the parental rights, doesn't understand the risk that she's taking. CPS report, they would be monitored and allowed her to keep the child with services with DCYF involved for the guardian. Yeah, these are all really important and difficult decisions. Yep, but accessing and starting child support from the father as well, and that would be certainly something that the guardian would be involved with. Thank you, Sarah. That's a good point. So these are really great conversations that are going on in the chat. So if you're not following the chat, this is definitely worthwhile to do. Thank you for your participation. This is really wonderful. I'm excited to see it. I hope that we see you over at the Center for Guardianship Excellence's events. I'd love to see some of the people here taking events and going to our trainings, and I'd also love to hear some of your cases. We do rounds every month, and we have a different guardian speak about a case that they work on. And I'd love to hear from some of you about some of the cases you're working on. It's a great learning opportunity and a good networking opportunity as well. So I'd love to hear from some of you. So thank you for having me. This has been a really great experience.
Thanks, Heather. Thanks for coming back, and you're here last year and back this year, and we're just grateful for you.
Thank you.
We're gonna break at this point. It's lunchtime, and so 12:30 is when we're gonna meet back for the next session, and so we'll plan on seeing you then, and see you here in a little bit.
Thanks, everybody.